Welcome to the USALI Speaker Series. I'm Jose Alvarez, the Faculty Director of USALI. So today, we are very privileged to have Greg Shaffer. He's the Chancellor's Professor of Law at UC Irvine School of Law, the Director of the Center on Globalization, Law, and Society. Many of you are familiar with Professor Shaffer's work. He focuses on international law, international trade, investment law, and he's addressed topics including his own invention, a new school, transnational legal ordering, which perhaps he will explain. Legal realism is another topic of his, hard and soft law, comparative institutional analysis, public-private networks and international trade, and of course, the rise of China and emerging economies. He's served as Vice President of the American Society of International Law. He's currently on the Board of Editors of the American Journal of International Law, as well as the Journal of International Economic Law and AGIL Unbound, as well as on the advisory board of the Journal of Transnational Environmental Law. He has previously taught at the University of Minnesota Law School, Loyola University School of Law, and the University of Wisconsin Law School. And for those of you who are curious how somebody becomes so eminent, he has his BA, magna cum laude from Dartmouth College, his JD from Stanford Law School, but he also practiced in Paris for 7 years for Coudet Frères and Bredin Prat, where he was a member of the Paris Bar. Those of you who are curious about his work includes 7 books, countless articles, and the subject today is 2 of his chapters, both of which can be found as PDFs, thanks to his kindness, on our website, chapter 6 and 7, from a forthcoming book to be published by Cambridge University Press in 2021 on rising powers. It focuses not just on the rise of China, but also India and Brazil. With that, the format of this, as usual, is we'll have a presentation by Professor Shaffer for somewhere between 20-25 minutes or so, followed by a conversation between both of us. And then I will look carefully at the chat box and Q&A box and get inspired from you and present your questions to Professor Shaffer. So with that, over to you, Greg.
Great, thank you, Jose, and thank you to your center. So this is, and thank you for this opportunity for publicizing my forthcoming book. This book is entitled Emerging Powers in the World Trading System, the Past and the Future of International Economic Law. And these are 2 chapters that address China. And the chapters involved intensive fieldwork in China, in Geneva, Washington, D.C., Brussels, where we interviewed hundreds of people and had remarkable access to those in China, in the government working on trade law policy, those at all the law firms who litigated all the cases, those leading academics who created new moot court competitions and worked with the government, and those in the private sector, including the development of new trade associations, in-house counsel for major state-owned enterprises, and so forth. And so it's really an inside look at this remarkable story of how China, not known for its lawyers, not known at the time that it joined the WTO, known for sort of a sort of Confucian culture in which litigation didn't play a major role. How did it take on the United States and the European Union in this international organization? And at the core of the book is really, in a sense, a paradox, which the book tries to address. And the paradox is this: the United States created the world trading system. It is the United States now that has been abandoning it. The United States created a system after it emerged victorious in World War II and then the Cold War. And political scientists viewed this as a strategy and viewed not the way most lawyers think about law in terms of rule of law, settling of disputes and so forth, but rather how the United States could rule through rules. And that's a quote from John Ickenberry, the political scientist at Princeton, who called the World Trade Organization part of a global constitutional order in which the powerful, namely the United States, exercise power through the sponsorship of rules and institutions. And so now the paradox is, why is it that the United States is abandoning the system that it created, and emerging powers, which complained that the system was rigged in favor of the United States and Europe? When I started to write and study and teach, this is a major claim. Why now are they become its supporters and its defenders of multilateralism and multilateral institutions? So if we think back in 1995, that year marked the 50th anniversary of the United Nations Charter, and it marked the 200th anniversary of the publication of Immanuel Kant's Toward Perpetual Peace, where Kant advocated the creation of a League of Nations grounded in law. So this is a time of triumphalism, of liberalism, of what can be referenced as legal liberalism, the creating of a liberal order. The United States now is challenging. The major media stories that we read every day in our papers are about the great challenge of our time, the rise of China, the decline of the US as a hegemonic power, or about the rise of how China is tapped into global supply chains and produces more efficiently than the United States, and now becoming an innovation powerhouse. And these stories focus on economics and on political power. But this story really is grounded in law, which otherwise is not captured. And the book assesses how Brazil, India, and China invested significantly in law and what I call trade law capacity to both defend themselves and in turn shape the international trade law system. It's the Chinese, as I said, provided us with remarkable access. They're more circumspect than the Indians and Brazilians, but overall, it's remarkable the openness at the time to discuss the challenges they face, their strategies, their litigation of cases, and their pride, literally pride in terms of how they developed a legal capacity to go lawyer to lawyer, head to head with the central forces within the WTO system, the United States and Europe. And just a wonderful small quote from, I can recall it from memory, but it's in the book, from a European Union official. It says that China now knows that we know what it knows. And that has changed the relationship. They know that we know they can use the WTO legal system to push back on us. And that's something we should is quite remarkable, and we shouldn't take it for granted. China faced a huge disadvantage when it first joined the WTO. Its accession protocol created obligations on it that did not apply to any other WTO member. So this was viewed as an unequal treaty by many. English is the governing language. The WTO is a combination of common and civil law cultures involving a jurisprudence, which is almost 100,000 pages of which if you're starting without any background, without English as your first language, and then aiming to participate and defend yourself in this, it involved at first a huge amount of study and a time when China was observing how this system operated before they started to engage with it. The other thing we should recall is that even though you see, the U.S. establishment now talking about how China, cheats, doesn't follow the spirit of this order. It was when China joined this system, there are divisions in China just as there are in the United States, and so there was huge pushback on the leadership when China joined. From the left in China, from neo-Maoists, and they had to manage and respond to this. So leftists and scholars and activists framed the WTO as part of a soft war waged by Western powers to constrain China. Reformers, in contrast, used the WTO, which literally, in a sense, became part of the China's constitution to transform the country and its and the role of law and the development of its of what could be referred to referenced as public-private partnerships in developing the economic system. And so, the book not only addresses China's development of legal capacity, but Jose mentioned by sort of the frame I use to think about international law in terms of transnational legal ordering, when it needs to look at the deep implications that this international legal order had within countries, including India, Brazil, but here China. So international trade law involves not just law at the international level, but dynamic interaction between states, within states, and with international organizations that implicate institutions, domestic institutions. So China had to change. It engaged in the largest law reform, internal law reform, probably in the history of the world. They created a system called cleanup of laws and regulations. And they went through all their laws and regulations and adapted them, abandoned them, revised them as part of the WTO accession process. And if you think about this, just pause for a moment. This would be unthinkable for the United States to sign an international treaty and then create an office of cleanup of laws to go through American statutes and regulations to make sure that they comply with the new system. In fact, I mean, the WTO largely reflects US law, which is what Eikenberry's point was, and which is what Obama's point in supporting the creation of the new Trans-Pacific Partnership is that we should write the rules and that others then should comply with the rules that we write. And so this is typical for US free trade agreements. For example, with Mexico or with Central American countries, when they sign a free trade agreement with the United States, part of the free trade agreement is that before it goes into effect, the United States is to review their implementation in terms of statutes and regulations. And only when those implementing regulations pass muster for US officials will the US actually then proceed to ratify the agreement. So it's completely asymmetric. And so we should think, when we talk about sovereignty and international law for other countries, it's a much different game than it is generally for us, even though clearly US sovereignty also is implicated, as Eikenberry notes. The point is that this incentivized within China large investments in law, in law-related professions, the patent profession, the patent accountant, the patent filer, the intellectual property judge, intellectual property officials, and so forth. This all blossomed inside of China after China became a member, so that now it's an intellectual property powerhouse. There's actually more intellectual property litigation in China than any other country in the world, which is traced in chapter 7 of the book. So even though the United States has legitimate and important concerns regarding intellectual property in China, the amount of transformation of institutions and professions just regarding this one domain is remarkable in China. So how did China, so chapter 6 basically focuses on how China developed this legal capacity within the World Trade Organization. Initially, the United States wielded huge leverage since it was the gatekeeper to China's WTO accession. And basically, the rules were in effect for the rest of the major economic powers, and China was pleading to become a member, and its accession was contingent on US approval. Once it became a member, what's also quite fascinating is the government launched a massive campaign to generate enthusiasm in the country regarding its accession, in part to counter critiques from the left and neo-Maoists in China. And so that you can read popular accounts of journalists going to, just talking to peddlers in the street who talk about the World Trade Organization, the great opportunity that this provides for their business. something is inconceivable again in the United States. And of course, that only happened through a massive campaign of the government. It even organized a national contest, which is a fun fact for me, regarding knowledge of the WTO, and which the finals was like a game show on TV as a quiz of who knew the rules the best. And the winner was flown to the WTO to meet the director general and have a photo opportunity broadcast on national television. We can't, it's hard to get, students to ascribe to our law students to take our classes these days, much less, the general population taking any interest in what would be viewed here as a relatively remote international organization. So the WTO really should be viewed as part of a broader opening up process in China. I mean, when it joined, I was a beginning law professor a few years after actually the creation of the WTO, and you'd have all these judges coming through the University of Wisconsin to be trained. And this was part of the 1990s sort of refurbishing of the Chinese legal system. But what's fascinating is the Chinese asked for a WTO scholar to give one of the lectures on WTO law, right? And that happened repeatedly. Again, something that is not the way our judges are trained in the United States. And by 2018, the Chinese legal bar had transformed. It had over 300,000 members. The judiciary had over 200,000 judges. And if you think about how the legal institutions were completely wiped out during the Cultural Revolution, this growing use of courts is something that we should take note. So that just the number of civil claims filed at the first instance in 1969, 62,000 cases. In 2019, around 15 million. So the government created new career tracks where WTO matters attracted ambitious, top, smart people. In academia, WTO law became part of a mandatory subject on the national bar exam. Clearly not something on the bar exam in the United States. The ministry, almost 2/3 of all funded research proposals, and clearly this is top-down research within China, state-led, almost 2/3 between 2007 and 2014 were for international economic law topics. To build students' understanding, they created the government's first WTO moot court competition with elite law schools. And this is the way, and both the major private law firms and the government ministries would be the judges and would attend these sessions to be able to tap into top Chinese and students for whom, even though this career did not pay nearly as much as if they worked in a large corporate law firm, was very prestigious because they would be defending China on the international stage. And so China, for all of its cases in the WTO, it hired the top US law firms to help it, but it always insisted that there be a Chinese law firm involved as well, which it viewed as this is to quote a US lawyer, a form of technology transfer. They were given access to the US law firm's databases. They observed, and gradually they started to participate, including an oral argument at the WTO. So Chapter 7 builds from China's success before the WTO to address how it's also following the example of the United States and the European Union to turn to bilateral and plurilateral trade and investment agreements. And as we saw on Sunday, China is now part of the largest free trade area or free trade bloc in the world with the RCEP, which was just signed. And it's certainly not as it's nothing like, of course, the European Union, but it nonetheless is going to be important, one, symbolically of just tying Asian countries together. Two, it's going to create common rules of origins across the entire trading bloc so that customs officials will, instead of having 15 different rules of origins, which basically become so complicated that traders don't pay attention to them, they'll just be a single set. And of course, tariffs will be decreased on to zero, the aim on 90% of all products, and it creates a template. And if you look at Chinese templates for its trade and investment agreements, generally they expand over time. And so I imagine we'll see this to be expanding over time as well. So chapter 7, what it addresses is how China is offering or intends to offer a new vision in which it places itself at the center of the transnational legal ordering of trade, finance, and investment in Asia, but also beyond Asia, as the Belt and Road Initiative extends to Central Europe, Southern Europe, as well as to the United States' own backyard. I mean, just this fall, I was asked by CARICOM, the Association of Caribbean Countries, to provide advice in their negotiations with China with respect to potentially massive trade and investment agreements. So this is global. The Chinese model involves webs of finance, trade, and investment initiatives, largely grounded in soft law in terms of memorandum of understandings, but also hard contracts, private law contracts, for which professional lawyers, in-house and external counsel are closely involved. Consequently, international arbitration becomes central to these agreements, but they're also backed by free trade agreements and investment agreements, which are public international law agreements. So it's a public-private international law model, but it's imbued with Chinese characteristics. It builds from existing models, which we can talk about, and its aim is to manage the risk to Chinese outbound investment and trade, and in the process, create a Sino-centric regional order in which the Chinese state plays the nodal role. It's obviously not completely new. It has its forebears with those of former colonial empires that built ports, railroads, roads, bridges around the world to extract natural resources and create new markets for manufactured products. Just as in those times, China will encounter local resistance while working with local allies to create economic ties to advance its interests. Chinese will make their fortunes in the process. In contrast to a liberal model of development grounded in private enterprise and the market competition, the Chinese model emphasizes the key role played by government planning and industrial policy involving massive investment in infrastructure. And here's a call on the left here in the United States for more of a turn towards this type of model. And the interesting thing will be to what extent will the United States learn from China as opposed to vice versa. It's a legal order which is grounded more in coordination of policy and commercial relations than in commitment in terms of litigated legal rights. It can be viewed theoretically in terms of layering on top of existing Western structures and models, but now with new Chinese ones. So if you think of the new Chinese development banks, you think of a new Chinese international commercial court to handle disputes, you think of the RCEP, free trade agreements, and so forth. You can see how they build on models, on templates that the United States has used. But they, in doing so, they become part of what I call a broader ecology of transnational legal ordering, in which different initiatives interact, coexist, and compete in complex processes that shape institutional development over time. So the chapter addresses the Belt and Road Initiative at the center, which is predominantly a private international law model based on contract and contract dispute resolution that paradoxically is state-led. As part of it, China is creating free trade zones, which build from its experience internally. And what's fascinating, you see Chinese lawyers who then provide advice to foreign countries about building the legal infrastructure for the development of these zones, learning from China's experience. which is, of course, a different experience, one that the United States simply cannot offer in terms of its own development model. So to complement, well, the central to this, what is we should, and this is of course to the consternation of the United States, is the government has massively supported Chinese technological development. It wants to be at the leading edge of sort of the new developments of artificial intelligence and the use of data for smart manufacturing. And it wants to develop standards for these, which become standards adopted elsewhere around the world. So just one anecdote, talking to a state-owned enterprise, which was responsible for developing major railroad in the Southern Cone of South America. Initially, the recipient country wished to use European standards for fast rail. But once it became familiar with Chinese standards, it adopted those standards. And China's goal is becoming very active in international standard setting organizations. And it views this as, in a sense, a form of law through architecture. These standards often are backed by intellectual property, including now Chinese intellectual property. And to the extent that they're adopted, they will become part of all Belt and Road Initiative private law contracts. And so this is the United States recognizes that this is a major development. I'll wrap up by just saying that the WTO's authority clearly is declining. Between the United States and China is not going to be easy to win. China has developed close economic ties with other countries around the world. It now trades more with a much larger number of countries than the United States. These countries have become dependent on China for their own internal development. China offers finance to these countries, and it also offers a development model where it doesn't require developing countries to make the same types of internal legal changes that at the height of sort of the World Bank and IMF interventions for loans and so forth would be required to reduce government budgets, to adopt particular capitalist standards for finance, as well as to adopt new environmental and labor laws. That's just simply not part of China's model, and so it's very attractive to many countries. And that'll be the challenge forward for the United States and Europe, and how to respond to this growing influence of China around the world. So I'll stop there and look forward to discussion and debate.
Sure. So, Greg, and so this is a fascinating 2 chapters. I strongly urge anyone listening and interested to read the material. Chapter 6 is, as Greg just showed us, an incredible story of legal development that is quite different from the usual story with respect to how the US, quote, complies with international law. Now, what I want, first question, and then I'll turn shortly to the Q&A. So by all means, all of you listening that have specific questions, and then I will turn to those questions. But one is, it seemed that your chapter 6 is the high point of China interest in the WTO and faith in it, seemed around 2018 or so. And then you tell a different story of how China began to see that the US itself was delaying compliance, playing games in its view with the WTO. And I'm curious if you think that there's been a disenchantment with the WTO dispute settlement system within China. How serious is it, and how committed remains China to, for example, getting the WTO appellate body unfrozen? Do you think, I know that China has joined others in crafting an alternative compromise whereby we continue to arbitrate without the appellate body. But apart from that, how committed is China to restarting the appellate body? And is there a deal here whereby you can see the new Biden administration and China actually unfreezing the appellate body of the WTO?
Yeah, so I think maybe three responses. First of all, there's no doubt that, and the chapter speaks about growing Chinese disenchantment with the WTO system, in part because in its view, it could be gamed. It saw how it felt that it was being gamed by the United States and Europe, so that even though when it would win cases, compliance would be delayed or compliance would be notional in such ways that the United States and Europe would continue to try to deny market access to Chinese products to protect themselves. And so this clearly was disconcerting for those, pushing behind these particular disputes, especially if they involve private enterprises. Also, one should think about this in terms of the role of debates within Chinese ministries. There clearly were more friendly WTO ministries and those that didn't wish to be constrained by international rules generally. The Ministry of Commerce in China is clearly the most WTO friendly and one reason is that both it defends its interests in the WTO, but it also has to respond to challenges. Let's see. I think I'm about to come
there
back.
it is. Well, yes, you sort of came back here. Yes.
Okay, I moved my computer, so.
Well, it's going back and forth, but we can still hear you.
Okay, sorry about this. Let's see. And so you found that part of this process was that the Ministry of Commerce within China no longer felt that it had the same authority in relation to other ministries to get China to comply with Chinese obligations. And so that was, so then there was this sense of, they became less powerful also within China, whereas initially their relative clout had grown. Nonetheless, in terms of how the state overall views the appellate body, clearly they believe that they've done better with the appellate body than they are without it. And they're better with binding dispute settlement than they are without it. For two reasons. One, the United States market is still incredibly important to China, and the tariffs have hurt China. And they recognize that if they could, that the legal system does provide them with some normative legitimacy in their terms of their relationships with the United States and trade conflicts. Two is they recognize that they actually did much better before the appellate body than they did before panels on average. And their view of this is the appellate body is a little bit more independent than panels of let's say, the pressure to take account of diplomatic sensitivities. And to the extent that the United States was the most powerful player within the WTO, there was a sense that having an appellate process, which was a little bit further removed from everyday interactions with the membership, that they did better with this. And so that's the reason why they still support it. That's the reason why they were working with Europe to have it reinstated. And a great challenge for the incoming Biden administration is what will be its position? And will it agree to the relaunching of an appellate body, or are they, which is in my view is they will not move quickly on this because they want to manage the transition between the Trump trade war and what they're going to do with respect to China, trade relations with China.
So, so that raises a ton of questions, but I guess I can't resist. So, in any way, was the Trump trade war helpful to disengaging the paralysis of the WTO? Obviously, we have lots of evidence that the tariffs were fundamentally paid by US importers as well as US consumers. So perhaps economically, it was a terrible idea, but did it accomplish anything?
It's obviously too early to tell. I mean, for the moment, still the United States is, and this is to quote a member of the WTO Secretariat, the wrecking ball within the system. So it's wrecked the system. The question is the United States using this as an opportunity to just to return trade relations to ones which are grounded in power? Or is the United States using this as an opportunity to fundamentally rewrite the rules? Fundamentally rewriting the rules will require the agreement of the entire membership, which will be very difficult to achieve because not just China, but India and other countries, they do not want the rules rewritten in the way the United States is suggesting. And so then the question becomes a normative one, Jose, which is, what is this better for sort of working class Americans? And I think that is potentially, they clearly have not done well over the last 20, 30 years. And so creating a little bit more friction between economic globalization and sort of the US economy, it does provide a sort of a recheck for us to go back to first principles as to how we want to address this. And with the World Trade Organization as being part of that, but not being sort of this centralized constitution-like order with a binding sort of appellate court. I think that everybody has realized that that the U.S. economy has benefited, but the mass of Americans have not. And so whether or not we're going to refashion through the WTO, I doubt, but putting the WTO in a place where it can still provide a forum so that trade wars do not escalate in ways which are mutually harmful, that's going to be important. But I see the WTO return to become sort of an enforcer of globalism in the way which there was a vision for that previously.
So you tell the story of US disillusionment with the WTO, and you say it as a paradox, but I guess I want to ask you, weren't there legitimate reasons that the WTO system that the US created to advance its own interests has not changed? The WTO has changed where the world of commerce has. So the complaints that the US has is, of course, you have SOEs, you have tech transfer, you have a number of subsidies that are not grasped by the current rules. You have rulings that say that particular acts committed by SOEs are not public acts, so therefore can't be captured by some of the disciplines. You don't have rules about e-commerce or many other developments that would benefit the US. And you have the colossal issue that China, one of the largest economies, soon to overtake the US perhaps, is still getting the benefits of being a developing country. Now, if you think, as the US obviously thinks, that the WTO should serve its interests, then you have a reason to be worried, right? And I guess aren't those concerns typical of when you create an institution that doesn't change enough over time? And part of the problem is the paralysis of the negotiating part of the WTO. And some would argue that one of the reasons for that paralysis is the sheer reliance on countries like China on the judges, on the appellate mechanism to clarify that a public actor isn't an SOE, and therefore that part of the problem is the sheer activism, or as the US puts it, persistent overreaching of the appellate body. Doesn't the US have a point?
So the short answer is, I think not really. I mean, as we know, courts always are going to make decisions which are going to upset some party. The United States has a much higher success rate than China does before this system. That generally the United States has pushed for what many view as activist decisions within it, in particular in creating greater grounds for social protections, environmental protections, the role for the ability for NGOs to file amicus briefs and so forth, which the rest of the membership opposed, and in fact, only the United States supported initially. And I think those are all good things. I think that where the appellate body made a mistake, which is, but I don't think is necessarily wrong, it's just a question of judicial interpretation, is it should have given more policy space to the United States to implement, to apply what the United States calls its import relief laws to protect itself from Chinese imports. It was more free trade oriented in this area to make it more difficult for countries to raise protectionist barriers on imports on a series of grounds that are otherwise authorized by the WTO, but are subject to interpretation in terms of how they're implemented. And everybody knows that the United States has always been the most aggressive of all countries in terms of trying to push the envelope of how it can apply anti-dumping law, countervailing duty law, and so forth to keep out foreign competition. And part of that is just because the United States doesn't have the same social safety net as Europe and other advanced countries. And so it just is more sensitive to the impact of imports and the ability of industries to adapt. That being said, on the particular case that you mentioned, I think that was definitely a mistake to say that Chinese state-owned enterprises are not deemed public bodies unless they exercise government authority. But even there, the appellate body actually found that Chinese banks were exercising government authority, so the US won. With respect to other enterprises, it kept open the door. It just meant an extra evidentiary difficulty. I think it didn't need to go that route. It could have just shown interpretive flexibility for the implementing country to decide that a state-owned enterprise is a public body. But, and so I think that is one of the examples where I would argue that the WTO needs to give countries the ability to protect themselves from the externalities of others' policies. What many, though, in the United States and elsewhere are claiming is that we need to create new rules to discipline the Chinese state-owned enterprises, new international rules to say you can't do this, you can't do that. In other words, international rules needs to intervene even more to constrain the way governments organize their economies. And this, I think, is a mistake. We don't know what's the best development model, what's the role of the state in development models. If in fact we believe that liberal capitalism is the best economic model and will always prevail in international competition, then let's just compete. And if we're so ideologically secure, we will win, right? Our model will triumph. And inevitably the government, the state will get it wrong, it'll misallocate its resources, it won't be as innovative and so forth. I mean, that's basically the US view. And so let it compete. You shouldn't need international rules to tell China that it needs to become more like us, i.e. the US. If China's actually doing things which are good for China in terms of the development policy, then it shouldn't be told it can't do those. But it's the WTO and the appellate body should be very wary of interfering with the ability of a country, such as the United States, to protect itself through labeling these imports as subsidies from a state-owned enterprises because it's a public body, from constraining its ability to what are referenced as safeguards to protect its industry from massive imports. Those tools all need to be available for countries. And it's the one area where I think the United States has a legitimate gripe. And it should be clarified in terms of the amount of policy space that countries such as the United States have to protect themselves.
So just to follow up, so should China continue to be given the benefits of a developing country status? And is it the same as treating India that way?
Yeah, so the answer to that is one, no, it should not be. The United States should insist that it no longer can benefit from developing country status. But two, we should need to put this in context. The benefits of China claiming developing country status within the WTO system are very minimal, right? I mean, it receives no benefits in the dispute settlement system. It receives a few benefits on the cap for agricultural subsidies and on some and on the thresholds when you can apply countervailing duties to subsidies. But China already meets those thresholds, so it's a symbolic issue, but it's not that material of an issue.
And what about a country like India?
I mean, look, I think India still has a much better claim, given the huge amount of real poverty in India, to invoke that status. And again, I think this status, India and China and other countries have opposed this. I think the status should be linked to some real numeric criteria, such as that the World Bank creates in categorizing countries. We may not be able to reach that agreement, and instead have to pressure countries just to no longer self-declare that they are developing countries, such as starting with Singapore, South Korea, and other powerhouses which have now agreed to this. Brazil recently indicated that it will agree to this for the future going forward. But and so China can as well. But we shouldn't think that this is suddenly going to answer, it's something which is symbolically important, but materially not that important.
So if it's not true that it's the appellate body's fault, why is it that the WTO has been sidelined as a place for negotiation, and instead we get the RCEP and these alternatives? Why is it frozen in terms of negotiating new lower tariffs, etc.?
Yeah, because it's a victim of its success. It used to be a small club organization dominated by Western powers, in which the United States and Europe could basically agree to a deal and then bring others along. And those others were generally not subject to as severe requirements as the United States and Europe, especially with respect to tariff cuts. That world simply no longer exists. I mean, so major things have happened. Three. One is it now has a huge membership, so it's much more difficult to get countries to agree, and it's just easier to agree bilaterally and plurally. Two, so it's much more like the United Nations. Two, you just have this major shift in power, so the United States and Europe simply can't call the shots like it used to, or no longer have the incentive to just come up with agreement and then say, well, yes, but you other countries, we're going to let you declare developing country status, and so there'll be different obligations that apply to you. And three, that the United States, one of its great successes with the WTO is it created what was referenced as a single package. That to be a member of the WTO, you had to belong to all 19 WTO agreements involving 23,000 pages of text, including schedules. That didn't used to be the GATT. You could have these ad hoc, pluralist agreements. Some parties would be members, others would not. So creating a single package just makes it much more difficult to come up with a common agreement than negotiating on a plurilateral through plurilateral initiatives. And so they're trying to institute within the WTO plurilateral negotiations, but other countries now are saying no. Under WTO rules, anything you agree within those agreements has to be applied on a most favored nation basis to all members, even if we will make no commitments under your plurilateral agreement. And so that's a problem.
So we will soon turn to all the questions that people have been patiently writing, and we will have a half hour for those. But I guess there's one last one. In your chapter 7, you say something about the Beijing Consensus as a different approach to, say, the Washington Consensus model of how China approaches its development associations with, say, the LDCs. And of course, China portrays itself as the leader still of the LDCs. And it has won considerable praise for not just its BRI, but others. Can you say more about what you mean by the Beijing Consensus? And I guess, does it really exist?
Yeah. So, it initially was invented and by outside commentators, right? And so China didn't come up with the term, right? Westerners came up with this term. But then China latched onto it. It's, and because this is part of also the sort of the shift that you see with President Xi, that China, didn't want to, it wanted to sort of be under Deng Xiaoping, it didn't want to look like it was asserting itself. It wanted to remain quiet, grow quietly. The term Beijing Consensus looks like it's a rival model that China suggests is a better model than the Washington Consensus, that tied countries' hands in terms of their internal development strategies. And so part of it is symbolic, that it represents now a rival model to the US model. And that's the reason why we address it. There's something to it though as well, which is, it clearly is a model which the state plays a much more central role in development policy. And you see economists such as Danny Roderick, Joseph Stiglitz, and others saying that it was the Washington Consensus was a mistake in terms of just telling countries you just need to create property rights and freedom of contract and the economy will grow, but that actually there were so many market failures that there's a central role for the state to be a catalyst of industries. And it's the only way to catch up with those who have a first mover advantage, such as the United States and Europe. And that indeed, most of the Asian models of Japan, South Korea, and now China and Vietnam have followed this other state-led model on which the state plays a more central role. So I think that there's law under this model has a different role, which the chapter addresses. But it's not a role which is completely alien to the way sort of what I'd call law and society scholars talk about law. So it's not a sort of this model of real bright line, clear rules that then that create rights that with which and mechanisms to induce compliance, legal mechanisms. Rather, it's more of a coordinative model in which law provides a channeling device to organize economic activity, but it can be adapted, amended. It's much more for coordination, creating ties and creating what are called in the US contractual literature, relational contracts. And if you look at the work of Stuart Macaulay, Ian McNeil and other contract law scholars, they say that actually contracts, you talk to corporations and they don't look at the bright line rules of the contract. They adapt their contracts as part of an ongoing relationship as needed. And if they actually litigate, that means divorce. That means the relationship is terminated. And I think you see then in the Belt and Road Initiative and China's different legal initiatives, lawyers play central roles, in-house, external, and in the government. And so you see this model is being used, and there's lots of law there. And so I don't think we should dismiss it either as just, quote, policy.
So let's start with the questions, and let's try to keep the answers short so we can go through a lot of them. We have 11 questions so far, and I think it'll only generate more. So from an old friend of both of us, Lucy Reed, if China were to decide to curry economic trade favor within the US in the Biden-Harris administration, what could it realistically do?
So I think there is, I mean, you mentioned earlier, Jose, about constraining certain forms of Chinese subsidies. I don't see that the WTO is the place where this is going to happen, but I think China could make some could agree to certain changes bilaterally with the United States. So just to give one example, since you mentioned the public body issue earlier in the WTO ruling saying that you're not a public body if you exercise government authority, unless you exercise government authority. I think China would give up on this point in a bilateral negotiation. It was in the Trans-Pacific Partnership, and Chinese leaders suggested that they had no problem with the Trans-Pacific Partnership and could even potentially join it at some time. And that agreement has much more constraining rules. So I think that's a signal that there's a possibility of some negotiations in this area. I think it'll be part of the problem clearly is not just that you had Trump in the White House in the United States, but also sort of the economic nationalist state planners have gained an authority within China under Xi Jinping. And so those who wanted to constrain the role of the state, they would have to also gain leverage within internal Chinese political contests. And so again, just as I said, it'd be part of this transnational legal ordering mechanism that certain players within the United States and within China would have to be able to gain relative authority professionally within their systems to be able to come up with some sort of compromises in terms of the interface, the economic interface between a state-driven model in China and a more capitalist model in the United States, which would permit the United States to raise tariffs or otherwise settle matters and manage trade in a more sustainable way.
So here's a question, and I'll just read it from Donald Clark. In your interviews in China, when the Chinese complained to you about the world trading system being rigged in favor of the US or other developed countries, did they ever identify exactly what they had in mind, what they would change? He claims he has economist colleagues who knows China, goes to the Chinese, and he asks that question, that complaint, but never seems to get a real answer. The system, he claims, has been tremendously helpful to China in the post-Mao era. China has done extremely well in trade since it joined the WTO. So what exactly do you find the Chinese interlocutors to be complaining about? And if there is an anti-China rigging somewhere, it's pretty hidden, isn't it?
Yeah, so it's great to get a question from Donald Clark, who clearly is one of the great experts on China. And so my response to Donald is that, this is the limitations for all of our work. The people with whom I spoke in China were generally those who were most engaged with the WTO system. They were not the people who sort of the really strong, sort of state-driven, nationalists, leftist nationalists within the Chinese government. So the people with whom we speak generally are going to look at the WTO rules as leverage for reforms that they want. But they clearly have opponents within China who view these as attempts to constrain a state-led model. Of course, they would point to asymmetric rules where, on export restrictions applying to China, such as on raw materials and so forth, that don't apply to the United States and other WTO members, and so forth. But the people who are generally were at the time leaders, the lawyers, right, who were working on these cases within the Ministry of Commerce, and the lawyers within the private sector and within law firms, they viewed this as something which was good for China, as you say. But they were not the most powerful players within China, so we need to remember this.
So here's a question about the US-China war. What can we ask the US strategy should be, rules versus tariffs? But I'm curious what Professor Shaffer thinks the goals of US policy should be. What realistically can be achieved between the two? Are we seeking to bring about structural change in China? Are we trying to circumscribe Chinese power? Are we simply trying to get fair competition with Chinese firms? Even if they are SOEs and their reach expands. And another question is, for example, what about the access of US internet and big data companies into China. Is that really what this is partly about?
Yeah. So I think that, I mean, those questions are, it's a great question. And there's no single answer because there's so many different factions within the United States which have very different views. So I do think there is an aspect of this which is just a realist perspective, a straight out, international relations realist perspective that China is now a rising economic power. Economic power is easy to transfer into other forms of power, particularly within the region of Asia. The South China Sea is going to be a major issue in terms of China's assertion of authority within the sea surrounding it as a great economic power, but also a military one. And so there are those, including in the national sort of security establishment, who this will be clearly a primary goal. And so the question then becomes, if international trade, the World Trade Organization, benefits the United States, but benefits China more than it benefits the United States, then we should step back from it. And we should only engage with it to the extent that these rules actually empower us more than they empower China. And so that's certainly an aspect of it. Clearly there are those, and I think there are, many of them are, I'd say sort of the liberal trade establishment who are focusing more on a structural transformation of China. The argument being that the spirit of the WTO is a spirit of global capitalism. China is a state-led economy, and that provides it with certain advantages, even though China would be, quote, and you always hear this, better off internally itself if it would abandon this state-led model. That the United States, it's unfair to US industries and so forth. And then sometimes it's not just economic, it's more the political economy within the United States in terms of trade is affected. And so the system simply doesn't work. I think the answer to this, as I mentioned earlier, is policy space for the United States to protect itself from China. And then there may be room as part of this, because as the United States protects itself from Chinese imports, that'll create incentives for China to come to the bargaining table. And so that is, one of the advantages of the Biden administration inheriting the Trump tariffs, so that gives it some leverage to see if China will be able to agree to some shifts, either in terms of its own internal governance, which I find to be less likely, at least to a significant extent, but at least in relation to the US ability to protect itself from, quote, unfair trade. And so in the third frame was mentioned unfair trade. And of course, here I see unfairness, not in terms of, well, industrial policy is unfair. I think it's a development mechanism that should be free for different countries in different contexts to decide for themselves. But you need to have the ability to protect yourself internally, including in regards to the political economy within your own country. And to the extent that trade policy has not been socially inclusive and others are being left behind, while some are making billions, we need to refashion our domestic laws and our international economic relations.
So in a prior iteration of the speaker series, we did have Tom Ginsburg talk about authoritarian international law. And I think you're familiar with the arguments of that. Do you agree that your new Chinese model in economics is consistent with Tom Ginsburg? Is this authoritarian international economic law?
Yeah, so it is consistent. I mean, Tom's a former co-author of mine, and I just, gave him all comments on his forthcoming book on this. I think that, my argument is that, and where Tom agrees, is that we should be wary of China as an authoritarian model around the world. And that's different than thinking about China's use of state-led industrial policy. The two are two different aspects. So as an authoritarian model of governance, which is successful for those of us who believe in and democracy and liberal rights. This is a major challenge of our time, and we need to come up with a stronger domestic model so that our model looks better than their model to other countries around the world. And that really is a competition of our time. Tom, in his argument, suggests that there's certain aspects of the authoritarian model which actually are attractive to many countries, with which I agree. And by that he means is that in some ways the liberal international law model is more authoritarian than the authoritarian model in prescribing domestic policy change, such as you have to have this type of finance, you have to have these type of free investment agreements, you have to have these types of labor laws, you have to have this type of environmental governance, and so forth. China's model is much more sovereigntist in the sense that we don't care, right? You can be Italy, you can be Kenya. We don't care as long all we're doing is building economic ties, and that's attractive. But of course, what goes along with that is China's potentially enhancing authoritarian leaders within these countries. So was mentioned the data-driven economy earlier. They will give access to surveillance technology, which is Chinese technology. As part of that, China will attempt to grab all of the data for their citizens, which then can be used for the development of Chinese products, just like Google takes data regarding us to develop itself. And so this is the challenge of our time. We need to create an attractive model for these countries, which is better than what China's offering.
So does the world trading system play a role in that kind of value-oriented reform?
So my own view is that the way it does so is not through prescribing certain laws that you must comply with, but rather permitting countries to raise trade restrictions to protect their own domestic social bargains. So for example, if there are labor rights violations, then you should be able to block those imports or raise tariffs on those imports, and that will create leverage in those countries to have better labor practices. But that's different than, say, the World Trade Organization creating its own labor inspectors.
So one question comes out about the BRI and other efforts by China to influence hearts and minds around the world. And of course, you know that critics in the US, including the Trump administration, call the BRI debt traps, basically, right? And yet there is some evidence that some of those policies are generating some pushback from African and Southeast Asian countries, including the sort of heavy-handed approach that China has taken, even on things like assistance on COVID. So to what extent is China really winning hearts and minds? And are there warnings here about where the BRI could actually be detrimental?
Yeah. So China is facing resistance as any new colonial power will face resistance. And so it will have to check itself. Clearly, there's a certain aspect to it where it has incredible financial leverage because of debt. It is a different form of leverage, though, than, say, private hedge funds in Connecticut, because they will balance not just the profits that go to China, but also their larger geopolitical considerations. So in some way, there's an argument to be made that that China has a greater ability to control that relationship so that the resistance doesn't become explosive than the Western model. But clearly, you see the way China also is tempted to use leverage to be able to take over freshwater ports. And that is going to be a continuing, ongoing story involving factions within different developing countries where China will build ties with certain leaders and certain economic elites, but others will be dissatisfied. And when power shifts, China will need to determine how it's going to manage those new relationships.
So when you mentioned how China layers on different organizations and perhaps remodifies them to the new Chinese international economic order, one question that comes up is, how do you see the role of the new institutions like the Asian Infrastructure Investment Bank? Do they have a kinder, gentler approach to conditionality? What do you see in terms of the evidence that they're actually adopting policies on corruption, on many other things that are different from the traditional Western IFIs?
Yeah. So is the chapter notes. I mean, first of all, the AIB has taken World Bank templates and has actually done most of its loans with the Asian Development Bank. So China is trying to show that it's a responsible stakeholder in running an international institution. And clearly one reason why it created these institutions in the first place is it was stymied in terms of its ability to enhance its role and its participation within the World Bank and the Asian Development Bank. And so it created its new parallel institutions. And so far those institutions are operating to a certain extent, based on the Western models. In doing so, I think one can argue that the Western models are changing as well. They're becoming a little bit more careful about how interventionist they are, because now China will not engage in the same sort of conditionalities, long, extensive contracts of conditionalities as happened there in the heyday of structural adjustment policies advanced by the IMF and the World Bank. And so I think you see Western institutions will be shifting a bit as well. But this remains to be seen. I mean, in terms of the financing for the Belt and Road Initiative, one of the great challenges in which you see a lot of literature and a lot of contestation is to what extent will this be sort of expansion of coal-based production that leads to greater climate change, or to what extent will China tap into its leading role in development of green technologies? And that's going to continue to play out.
Right. So another series of questions, as you might expect, is TikTok, Huawei, and national security. So we just had a huge event in the Council on Foreign Relations. Over 500 people tuned in on TikTok. I'm not sure whether they really were concerned about national security or just love TikTok. But the question is, how serious is the national security threat that CFIUS should examine in a future Biden administration from things like TikTok? Is this really just a way to dump on China conveniently? Or how should we, if you were advising Biden or as part of CFIUS, tell the difference between a real national security investment threat coming from China investing in the United States and one that's really not serious?
Yeah. I mean, part of the problem in the United States is just how we complained about the non-transparency of China. CFIUS is completely non-transparent. And certainly the Trump administration has been completely non-transparent. So we simply don't know. The UK, for example, in its process of reviewing Huawei was much more transparent in terms of publishing government reports, independent expert analyses of the risks, and so forth. So my own sense, based on the information we have, is that Huawei is a significant risk in terms of developing infrastructure, which potentially can be vulnerable, including to cyber attacks, or other form could even be stopped momentarily if there was a conflict, say in the South China Sea, and we simply shouldn't subject ourselves to that form of vulnerability. A TikTok uploading apps, it just doesn't seem to me to be a national security issue. It seems rather to be a domestic political play, and it doesn't seem to be helpful. I think that it will only enhance sort of the role of nationalists within the power of nationalists within China. It will stoke a nationalist response.
And so I think that we need governing principles, and those principles should be that national security is they need to be given policy space to adopt measures on national security grounds. There should be some sort of more transparent domestic processes, including administrative law processes involving due process and giving of reasons. And there should be some, to get to TikTok, one could imagine it'd be more legitimate for the government to say that government officials and military officials cannot use the TikTok app because you're concerned about data transfers or location information. But for common citizens, it seems like an overreach.
And I assume your solution would not be that if you found TikTok to be a threat, the solution is to insist that that secret sauce be given to Oracle.
Yeah, a mandatory sale of a Chinese company to a U.S. company, and a tit for tat response in China. That does not seem to be helpful. We need to manage our economies, but this seems to be just about stoking up tensions for domestic play.
So with respect to CFIUS, though, obviously everybody knows that a lot of countries now have national security screening mechanisms, many imitating CFIUS. One possibility is those kinds of transparency, due process issues could be reciprocally insisted upon. Yes. So that to the extent China has the same, do you think that's even realistic?
Well, I think but that's what trade negotiations are all about. At the core of them, it's about reciprocity, and so this would be a fair negotiation, right? But the principle should be proportionality. Our responses should be proportionate. So it'd be fine to take proportionate responses for infringements of one side by the other. But this does not seem to be anything triggered this other than something internal to the United States. And it's hard to see what's being gained if there was a strategy, right? So what you're suggesting, Jose, is that there's some sort of strategy to use TikTok as an example as part of a greater negotiation with China regarding how it treats U.S. companies. That's fine. Then say it. That should be part of the negotiation. But that hasn't been the case. Rather, this has been just a series of tit for tat unravelings of economy without any real principle as to what the real national security issue is at stake.
So here's a question that is basically asking the U.S. to ask itself what it wants. Is there a risk that if the U.S. continues to pursue the old free trade mantra, that it ends up as Great Britain in the late 1800s, when faced with protectionist United States or protectionist imperial Germany, protectionist imperial Japan? And that pairs off with a question that says, well, why not? Why shouldn't the U.S. adopt China's state-run or more state-run industrial policy? Are those the choices, and what would inform those choices other than different pairs of Democrats and Republicans in the United States?
Nothing would inform those chapters except different pairs of Democrats and Republicans. It's a domestic political choice. We should engage in more infrastructure development. We should engage in more industrial policy on key technologies, on science and technology and so forth. But we're so politically polarized, it'll be difficult for us to actually pull that off. But we should learn from China, just as we should also protect ourselves from China. I mean, the danger with respect to comparing the UK is that the UK didn't face the fact that it was a declining power. And there are limits to what we can do vis-a-vis a relatively declining power. But it's naive to think that somehow we're gonna stop China. We need to manage this relationship with China. And we need to protect ourselves in doing so. And part of that, given China's policies, involves, in my view, enhanced industrial policy and strategic government action. But that's a domestic political choice subject to domestic political debate, over which nothing constrains us from responding in this way.
So a couple of your answers remind me of the question posed to the ghost in A Christmas Carol. Is this the things that may be or must be? And so putting aside what you predict could happen, what should happen with respect to, say, viable WTO reforms that could actually get us out from where we are. Lighthizer from USTR in his Wall Street editorial suggested we go back to what sounds like a GATT type approach, where ultimately the state parties can overturn whatever decision is given to the impartial body, and there is no appellate body. I suspect that's not where Biden will want to go, but I am curious what kinds of reforms to the appellate body, if any. There's a number that David Walker and a group of states have suggested. Is there anything there that should be done? And I'm thinking everything from the types of remedies it has, right, which are limited to some extent, to the second look, an enhanced second look by a political check, to a more careful discussion about the role of precedent or judicial minimism in terms of not arguing beyond what the litigants present. So can you give me a little snapshot of what might be, but not by predicting it, but what should be?
Yeah, okay. So I think, I mean, there's three broad, big options, right? And one can combine a combination of all three. So first of all, I think the membership, including China, has agreed to reform the appellate body procedurally in terms of a large list of issues, which is a formal paper submitted jointly by the European Union, China, and other countries, as well as what was called the Walker process after New Zealand's ambassador to the WTO, which when I interviewed him, he had a very nice quote, which he said that, we would like the ocean that surrounds us to live by its name. So I think, in part of this, I think more than just the procedurally is that somehow you'd have to have an understanding that countries would be given more policy space to protect themselves, such as through US import relief law. That would have to be part of a substantive deal to go along with the procedural ones. So that's one option. A second is just given the range of national security issues that naturally have become more salient because China is now a great power and technology always has dual uses, military and civilian, that one needs to think about other non-adjudicatory processes for managing disputes, conciliation, committees, and so forth. When these need to be, and that would include, importantly, giving space for bilateral negotiations. The idea that not all this is good, that you have to give policy space to countries such as the United States to protect themselves. That'll spur bilateral negotiations, and potentially then they can reach a response. But under WTO rules, if there's going to be any, that trade measure can be subject to proportionate responses to create a rebalancing of concessions, which would result higher tariffs and slight, modest decoupling or potentially, greater decoupling of the two economies than under a pure free trade system. That should be totally legitimate. The third, which I think the Biden administration should seriously consider, could be considered variable geometry for dispute settlement, which means that different countries could have different dispute settlement processes for different trading partners. So you could imagine that you could imagine this in two ways. One is some countries could agree to an automatic appellate mechanism, and others could say we're going to have a single stage system, say with a permanent list of, say, 15 panelists, which would meet in groups of 3. That would be less authoritative of a system as sort of a pinnacle supreme trade court. The other option, which I think should be seriously considered, is the United States simply say we do not recognize binding dispute settlement with respect to China, but we do with respect to everybody else. And other countries can say this as well. It preserves overall a binding compulsory dispute settlement for most countries, but it would be on a reciprocal basis, in a sense like Article 36 of the ICJ. So that, okay, as part of our bilateral understanding, we will reciprocally agree to this system. And I think Europe and China would have already agreed to do this with themselves. That would create, you'd see other potentially the United States and the Biden administration could do this with everybody but China. But even if we were to go this route, and I think it may be important, at least as a transition moment. Remember, and this is what's lost in debates, is the US never has to comply with a dispute against China. It can simply refuse to comply, and retain that right, and then China can has the authority to withdraw equivalent amount of concessions. That's the way the WTO works. And so even under the existing system, it's not as if this binding dispute settlement system is all that binding ultimately.
Okay, so we have unfortunately run out of time, but I'll ask you one last question and you can just answer yes or no. Would you accept the new position of USTR head?
I normally
Yes or
would.
no?
I normally would, but now I cannot because I have another obligation.
Okay, well, that's very polite. But thank you all, and thank you all for participating. And see you next time after Thanksgiving. Take care, Greg. We appreciate it.